But back to your point, it's unclear if prosecutors will try to indict people who were not advised at the time of their plea about the consequences of the 3 strikes law. I venture to say that they may try to do that, because if they don't, then no one can be indicted as habitual offenders under subsection B for quite some time until they've been convicted and then served time under the first 2 strikes. So I agree with you that there are serious due process issues, and I think that's what that portion of the bill is meant to address. But it's unclear to me exactly how prosecutors will implement it. Now, with regard to the other section that incorporates all of the felonies, that one does not have a similar provision. You don't get advance notice of that at the time of your plea, probably because it's very similar to the existing law. So you can have those strikes that happened many, many years ago counted against you as one of those 688 felonies. The only difference is you couldn't be sentenced to the life without parole. It would be the maximum you couldn't be sentenced to the maximum without parole. You could instead be sentenced to the maximum with parole eligibility after 2/3 of that maximum sentence. Still quite bad, especially considering the fact that the parole board at this point is releasing very few people on parole. Parole releases, since the new board has been put in place, are down 56%, which is another thing that's contributing to the extreme overcrowding of our prisons.
Just wondering if we could continue to have this conversation and meeting at a more personal level with our local official. So I think that some of our local officials would be beneficial to have the conversation in a personal level. I think for them to even understand what's happening, because then our district council, our local officials here, our city council, can also advocate with our state reps. So there's a relationship that is established between local officials and state representatives, especially in our Senate. So, hopefully as they become educated and know what this is about, and so just like the gentleman said, in fairness, just hearing the other side. So somehow I'd like to encourage that we begin to also have a local, strong, a pretty aggressive campaign with our local officials and see if we could get a commitment from them to see if we could actually press forward just to have our state reps be able to hear the other side. Will you just sit in here? So much like myself as a city councilor, I commit to doing that. I commit to passing the information to the reps that are in my district and being able to say that, please hear the other side.
Thank you. It is all of our responsibilities to hold them accountable for these things that are going on in our community.
Yes. Please, I just want to say that we put together a newspaper. So I know some of you may have it, but there's a newspaper over here that kind of contains a lot of this information. Some of the entries from Prison Legal Services, from Mr. Thompson Criminal Justice Policy Coalition, as well as some of the other people you mentioned. From Judge Nancy Gertner, Professor Ogletree, and all that. So those newspapers are over there, and it's an excellent way to kind of have everything in your hand, a handy-dandy reminder, phone numbers, and all that. And I encourage you to please take them. Thank you.
Thank you. Mr. Bateman?
I have a question. Mr. Flanagan here stated about 2 felonies after 30 years, and they can use that against you. How about after those 30 years, can the DH still use your record against you if it's sealed?
Ms. Bennett, can you answer that?
It would be guessing. You want to guess with me?
You go first.
My guess is that a sealed record is just that. It's sealed and it can't be used to trigger a strike. Do you know anything different for that?
I can't give you a definitive answer. I've never really come upon that. But generally, in my experience, convictions for serious offenses aren't sealed. What's sealed, for instance, are entries in your quarry that you don't want people to see when they're running your quarry. But I don't think that, the kinds of crimes that we're talking about that count towards the habitual offender provision, I can't imagine those being sealed, actually. So I don't really know that that would come into play a lot. So I guess that's the best answer I can give you.
So I can actually answer that question. When you seal a record, it doesn't change its status as far as the courts go. That's the difference between sealing and expunging. In Massachusetts, we don't have expunging, we have sealing. And if your record is sealed, then employers, landlords don't have access to it. It comes up and says no record, just like you have no record. But courts still have the same access to it and treat it the same as if it was fresh and open from yesterday. And as for, it would still trigger a third strike under the subsection A, which is any felony, where you wouldn't get a maximum sentence without possibility of parole, but you would still get a maximum sentence with parole at 2/3, and those crimes are certainly sealable.
Thank you, Steve. Do you have a question?
Yeah, I'm just wondering, do you think that it's possible that the vote could be delayed if with enough public pressure?
I think it's possible. There are two things that can happen. One is that if the conference committee doesn't agree on a compromise bill, then it dies there, and they've got to start over. But remember, when you're on a conference committee, you've got 3 senators and 3 reps who have already voted in favor of their version of the bill. So that's a lot of changing of minds to do. So that's the first issue. But I think one of the things that I've seen is that it's meetings like this. The House and the Senate leadership and the executive branch, they know when people are coming out and asking questions. So I think it's my hope and my own personal belief, and there's nothing that I can hang this on. What we've been trying to do is we've been trying to get the governor to make a commitment to veto. And that whatever comes out of the conference committee, he vetoes, and then we need 1/3 plus 1 to sustain his veto. So we need 1/3 plus 1 of the House or 1/3 plus 1 of the Senate. We're hoping that by holding meetings like this, if the governor does veto, that then locally you can impact your state reps and your senators. And again, I have no problems with starting over and crafting a habitual offender bill, but I think this is too broad, and I think there are going to be people who get caught up in this who do not deserve the amount of time that they're going to get. And at the end of the day, I believe California is still a good example. We're going to pay for this. You're going to pay for it your entire working life. Because remember, the first striker in California doesn't come out until 2019. So you're talking about people who will be third strikers who are going to either be there forever, or they're going to be doing 25 years before they go to the board. Not 15. They're going to be doing 25 before they go to the board. We pay for that.
I wanted to touch on the CHINS part of it, and as an adult, I know from my own personal experience that my CHINS, my truancy, is still accessible through the course and everything like that. Now it's like I'm wondering, is that when I go for a job and they run my Corey, is that on my Corey too, or is that just court access?
It's just on the court access piece to it. It's not technically on your court. It's on your court access piece. So let's say you were to be arrested again, God forbid. But if they ran your name, they would see that you were a CHINS kid, but it won't show up on your court. It's only within that court system that that's a record of. What we're saying is that you can't enter it in the court system anymore. And if you do enter it in the court system because the family decides to go along with the CHINS, once the CHINS is wrapped up, it has to be expunged. There's that word, expunged. Not sealed, expunged. So once you're 18, if you were a CHINS kid, we're taking that off your record with the new law.
So moving forward with the new law, that would go off my criminal record?
Yes.
Instead of having my probation officer looking at me now, going through it, what was wrong with you as a child?
Yeah.
That's what I'm getting now in court, you know what I mean?
Absolutely.
And this is your whole life, I'm going to keep you on probation for life,
That's the stigma that we're talking about. It stays with you. No matter if you got into a fight with your mom and dad were told to file a CHINS, you're going to get that stigma for the rest of your life. Interestingly, you were talking about, there's 2 points I want to make about the connection here between these 2 bills. One is the probation officers are the ones that are stopping our CHINS bill because they're worried they're going to lose their jobs. Well, there's their jobs right there in this next bill. And the other interesting thing is that the state is saying that this CHINS reform is going to cost $20 million to implement. We can't figure out how they took the most expensive kid ever on the face of the earth and multiplied it by 9,000 kids that are in the CHINS system, and that's how they got to that number. They blew up the number out of the water, and in this case, they're blowing it down. So it's like what they want to see happen is how they make the facts around the case. So, you know, what speaks to that point is, if this passes, we got to start with the kids younger, okay? If we can fix the system then, we won't have to worry about any strikes. Hopefully there will be no strikes against anybody. I mean, that's our goal in trying to get this CHINS reform from the beginning, so you're not looked at with this stigma. So thank you for saying that.
Dan? These forums are very, very good. What Mr. Thompson said makes total sense. Does everyone know who their rep is in the area? Hands? Everyone? Not that many?
I do.
Please call that number that was given out and just tell me your address, they'll tell you who your rep is. I've been in the office, I've been in 2 offices. I was with Mr. Pedoni, now I'm with Mr. O'Day. And the reps that we have in this city, I know them personally, they're very, very honorable people. I'm causing myself more work here because I'll be the one taking the calls. But if you don't call, they don't know how you feel. Please call, because then the message is relayed to them. It will make a difference. Because does everyone vote? Yeah. Raise your hand. Okay, there you go. You have to call to raise the issues. That's the only way to do this. I mean, these forums are great because you leave here, hey, I was at a good meeting last night and the word spreads. So I'm just telling you, please call the office and tell them how you feel. That is the number one thing you should do. What Mr. Thompson said makes a lot of sense.
Thank you, Dan. Thank you. That number, once again, is 617-722-2000. And just ask for your rep. Tell them what district you're from and ask for your rep. Mr. Friedman.
This is Aaron, and I'm hoping that I can word this correctly, that I can receive the answer correctly. The CHINS reform, and I... that process, proposed reform, is it a different process with someone that may have gotten placed in foster care as opposed to someone that has their parent with them? Is it the same process, or because I think like you can advocate for your kid, then somebody that's been placed in foster care or maybe even has run away out of foster care. So I'm just wondering about how that works with them.
Right, so the way that it would work is that the same people will be allowed to file a CHINS. So it's a police officer, a truancy officer in the school, or a parent. If the school or police officer files a CHINS, what it will be called FACES, but if they file a CHINS on a foster kid, not only does the state get notified of the CHINS filing, but the foster parents and the parents if the custody has not been taken away of the parents. So if I still have legal custody of my kids and I'm under an investigation and they're in foster care, the state has to notify me that this is happening. Not only me, but their dad too. Like if there's, so both parents would have to be notified. So does that?
Yeah, I'm just always thinking of,
But if legal custody has been taken away from the parents, they will not get notification of this because technically they don't have custody of the child. It would be the Commonwealth of Massachusetts that has custody, and it would have to be the foster parents or wherever that child was residing who would work with this CHINS. The goal, though, let me tell you, the goal is not to file a CHINS anymore. The goal is to get the services through the community resource centers. So while the door is going to be open in the court, before you can even fill out the paperwork to have a CHINS start, they have to say, have you gone to the community resource center? Have you received services? Have you gone through a truancy prevention program? We're not even looking at you until you tell me that you've done these things. we're trying to put in every single thing, and we're trying to educate, because like I said, 3 people can do it, the cops, and that's only if there's a runaway. The school, which means they have to go through a truancy prevention program before they can show up in the courts, and the parents are gonna be told, have you tried this community service thing? And if you have, and you still wanna do this, here's what's gonna happen to you, and here's what's gonna happen to your child. No more of this not making an educated decision just because everything's going to be okay and we'll pat you on the back. We're not doing that anymore. It's not fair to anybody involved in the system. So I hope that kind of answered it. Okay.
I have a question. People who already have CHINS,
Yeah.
such as Lori,
Yeah.
Will that record be done if this does go to front?
Right now, that's not